Hi, everybody. I'm sorry that I can't be there in person to join you. I'm stuck here in federal court in Houston. Just finished a long 10-hour day in court. I have to admit, I haven't really been able to give much thought to what I'm going to say to you all. But I think I'll just talk a little bit about our work. And maybe since my mind is on our trial here on the Harris County money bail system, I'll probably speak a little bit about that. A few years ago, I started bringing civil rights lawsuits to challenge the notion that a human being can be kept in a cage when she can't make a monetary payment. First, we did some cases in fines and fees and court debt. And one morning I was in St. Louis, Missouri, just watching first proceedings. And I saw a woman in court there who had been in jail for a few weeks away from her newborn child. And she had $100 cash bond. And she was told, plead guilty, get free today. Or if you want to fight your case, I'll set you again in a few weeks. And I watched this woman who had just given birth to a child who was separated from her newborn baby for, at that point, I think it was 2.5 weeks. I watched her say that she was innocent, but that she wanted to get out of jail. And I watched the judge walk her through a plea colloquy. And I thought to myself, surely these cases that we've been bringing in the post-conviction context about whether you can jail someone when they can't afford their fine, surely we can start bringing these cases into the pretrial context where you haven't even been convicted of anything yet, and yet you're stuck in a cage just because you can't make a payment. And so I started spending a lot of time. That's actually when I first met Charisse. I had my first meeting with her a couple of years ago, and I said I want to do this. And I want to start challenging the constitutionality of money bail. And a lot of other people, I think even including Charisse, thought we were kind of crazy. And it was the predominant system in all 50 states. But slowly but surely, I think our work has centered around chipping away at the dominance of a money-based system in at least two important respects. One is for the lawyers in the room, sort of a legal doctrinal respect. We're trying to vindicate a very simple set of legal principles. The first legal principle is no human being can be kept in a cage when she can't make a monetary payment. The second legal principle is that we shouldn't deprive people of their fundamental right to pretrial liberty, a presumptively innocent person, unless we have really good reasons for it. And our money-based system was violating both of these principles, what I think of as the equal protection principle, this we have to treat people equally. We shouldn't decide whether someone is caged or freed on the basis of whether they have enough money in their pocket. And the due process principle, which is that when we do something this significant to someone, to their body, to their family, to their community, to all of us, to our society, we have to have very good reasons for it. And not only do we have to have very good reasons for it, but we have to follow particular rigorous processes to accomplish that kind of decision. So our cases have been really focusing on getting the federal courts and in some cases state courts to scrutinize those two principles and to apply those two fundamental principles to our money-based pretrial release and detention system. And then the second major area, I think the more important area that our cases are really focusing on, is trying in some small way to be part of a movement that changes our culture, changes our legal system and the people that work every day in it. And it resensitizes that system to the enormous brutality inherent in putting a human being in a cage. I firmly believe that we won't change all of these ingrained habits and practices just with a few court victories here and there. And in fact, we may not even get any court victories of any real significance until this cultural change takes hold. So that's why in a lot of our cases, we don't just bring these legal doctrinal arguments. We really try to tell the human and community-based stories about what's happening in our bail system and why it's so devastating to all the people that are caught up in it. And I think it's those stories that have captured, at least in the cases that I've been involved with, those stories that have captured the local media, in some cases the national media, and those stories that have connected with a lot of the great work that a lot of other people in the pretrial movement are doing, the great work that the Pretrial Justice Institute is doing, telling those stories and providing the kind of technical assistance and other guidance to jurisdictions and stakeholders all around the country to get them to want to create a different system. It connects with the work of other advocacy organizations, nonprofits, community organizers, public defender associations, and people that train public defenders like Gideon's Promise. All of us, and certainly people in the media, and all of us are combined with one voice. We're talking about these issues. Folks at Color of Change that are taking some of these stories and emphasizing some of the terrible aspects of them. And so our legal cases are intended to exist in the context of a broader attempt to shift the public narrative. And just for example, today I was in federal court here in Harris County, Texas. And in Harris County, Texas, we have a money bail lawsuit challenging the common practice in Harris County, Texas of keeping people in cages after their arrest because they can't afford to pay. And so powerful is the community-based support, the media, the local buy-in from people of all walks of life, that today in federal court, we closed our case by calling one of the defendant judges who sat in court and told the federal judge that he believed the current Harris County money bail system was unconstitutional. He didn't want to participate anymore. The district attorney of Harris County filed a document to the federal court saying that she no longer wanted to be complicit, that's her word, in the illegal jailing of the poor. And then finally, we closed our case with the sheriff of Harris County, who testified that being in his jail on a bond you can't afford shouldn't be a death sentence. Our jails are places where bad, unsafe things happen to people. And in many places around the country, they are an abomination. And the Harris County Sheriff said there is no law enforcement purpose served by keeping people in jail solely because they can't make a monetary payment. In the audience were numerous local officials, judges, community members, advocates. I don't think that kind of hearing would have been possible when we first started doing these cases a few years ago. And yet we got to the point in the nation's third largest county and third largest jail system where numerous people who have worked in the system for many, many years were willing to come in and tell a federal judge under oath that this system is destroying their community and devastating lives. So that's a little picture into the kind of work that we're doing. And I think is there a question and answer period now? Because if so, I'm going to go, if not, I'm going to go take a nap. But if so, I'll take a couple of questions.